Welcome, everybody. This is the final in the spring series of the Information Ecology lecture series. Our speaker today is Professor Catherine Fisk, a recent arrival at the Duke Law School, and we can now admit to the full law school faculty and students that which we perhaps didn't mention as assiduously in the process of recruiting, that we have hired yet another person who works in a fascinating, interesting, and historically informed way on intellectual property. Soon everyone at Duke Law School will teach intellectual property. Among the many reasons to welcome Catherine and Erwin to Durham is that she has done some of the most interesting work on an aspect of intellectual property that we have not previously considered in this series, and which all too often goes uncovered, unnoticed. We've had a lot of interesting talks over the course of the semester, and I've seen a number of you at them, and a lot of those have focused on the issue of innovation. How do we encourage innovation? What's the correct balance of property rights and of freedom in order to encourage innovation? Should we or should we not have gene patents? Can open source biology provide a way of generating medicines for neglected diseases and so forth? One of the things that all of those talks presume and perhaps leave to one side is the question of in what institutions does innovation actually take place? We think of giving intellectual property rights to innovators and perhaps to investors. But of course, a large amount, perhaps the majority of innovation in the United States happens inside a corporate form. And thus, we have to meet the utterly crucial question of who owns and who controls intellectual property that is generated by employees. And as Catherine's book in progress develops, and her wonderful articles, which I strongly recommend to you over the last 4 or 5 years, have indicated, to understand that question, you have to turn to the history of what is, in fact, the juncture between labor law, corporate law, and intellectual property law inside the United States. That's the subject of her talk and her very interesting paper, which you can download from our website. So please welcome Catherine Fisk, who's going to be talking on working knowledge, employee innovation, and the rise of corporate intellectual property, 1800 to 1930. Thank you.
Thank you. It's wonderful to be back in this room with so many former students. I'm delighted that you all made the time to come. I'm particularly delighted to talk about my book on the legal history of knowledge and intellectual property in the context of the 19th century employment relationship, because I've spent the last 7 or 8 years reading obscure old cases and immersed in the archives of 19th century firms, looking for things that most labor lawyers aren't interested in, intellectual property scholars don't know much about, and that the archivists of these various company archives insist isn't there. And I've often wondered whether when I finish this book, and I swear I'm going to finish it this summer, whether my sort of unique and I think really interesting synthesis of labor, business, and intellectual property history will be of any interest to anybody except me. As I've been wandering down these various streets of labor history, intellectual property history, and trying to find where they all intersect, I think I've been a kind of a solitary traveler. And so I am delighted to have this opportunity to share some of my stories with you and maybe to convince you that, that it's a really fascinating field. Before describing the history of the origins and development of corporate intellectual property, let me explain what I'm talking about for those of you who are unfamiliar with the terrain. Since about 1930, firms have been entitled to the intellectual property produced by their employees. The corporate employer owns the patents to inventions developed by employees and independent contractors on a number of theories, but courts typically conclude that the inventive employee has either explicitly or implicitly agreed to assign the patent as a condition of employment. Corporations own copyrighted works, because the corporation is usually deemed to be the author of any work made for hire. In addition, under the law of trade secrets, firms control current and former employees' use of a wide range of economically valuable knowledge, and any innovation or knowledge, idea that happens to escape the grasp of the employer through those legal categories can usually be controlled through contract in the form of what's known as a restrictive covenant or a non-compete agreement or a non-disclosure agreement. In 1800, when my story begins, employers enjoyed almost none of these rights. The employee inventor owned the patent, the copyright, and there was no law of trade secrets. Moreover, through contract, it was relatively difficult even for an employer to contract around this regime of employee ownership. Business practices reflect that many employees considered themselves at liberty to make the most of the knowledge that they acquired through their work, and most employers believed that they had few ways to prevent the loss of information entailed in employee mobility, because economically valuable knowledge and employee skill were widely considered to be the attributes of individual employees rather than the assets of firms. And so my story, roughly speaking, is the story of change between 1800 and 1930. What I'm talking about today can be divided into three parts. The first part will be descriptive, using selections from some of the business history that I've uncovered. I'll talk about the principal stages of legal and especially business or social change in this area. The second part is going to be explanation. Why did the law insist on employee ownership and control of economically valuable knowledge in the 19th century? Why, as a matter of business practice, did firms acquiesce in that, even though they were acutely aware of the value of technology and the threat that employee mobility posed to monopolies in technology? And then third and finally today, I want to talk a little bit in normative terms about the promise and the peril of my project, and in particular, the question of what I'm doing when I'm expanding the framework of intellectual property to include various employment law doctrines that neither in the 19th century or even to many people today are really included conceptually in the ambit of intellectual property. So let me begin briefly with description. As I said, in 1800, the legal rights of employees or of creative people who worked for others, the category of employee didn't really exist then, was not very closely attended to. In a sense, it really fell into both a legal and intellectual lacuna. But the result of that was employee ownership. The effects of full portability of human capital and the relatively unrestrained diffusion of innovation on business practices can be illustrated by an episode from the history of the DuPont company. In 1800, Eleuthère Irénée Dupont de Nemours, and if I got it wrong, Dorianne Coleman will correct me because she speaks French a whole lot better than I do. He was a French aristocrat who prided himself on having studied the chemistry of gunpowder under the great Lavoisier, came with his family to the United States to start a business and, not incidentally, to escape the difficult position that aristocrats found themselves in after the French Revolution. The family bought a lot of land along the Brandywine River near Wilmington, Delaware, and built a gunpowder mill and commenced a business in 1802. DuPont correctly believed that his superior knowledge of the chemistry of gunpowder would enable him to succeed in business by manufacturing gunpowder of a higher quality than any then available in the United States. A Virginia-based firm, Brown, Page & Company, sought to build a powder mill in Richmond, Virginia, and eager to learn the best new techniques for the manufacture of gunpowder, they sent an agent, a man named Charles Munns, to Wilmington in the autumn of 1808 to recruit powdermen from DuPont's mills. Munns set himself up in a local tavern known as the Buck, where he entertained DuPont employees and offered to pay them wages in excess of what DuPont was paying if they would agree to go to Richmond to work for Brown Page. Munns also inquired about the machines and techniques that DuPont was using in the different parts of powder manufacture, and he was particularly keen to get a brass pounder and some parchment sieves that were used to mix powder. I learned a whole lot about gunpowder manufacture in my time in the DuPont archives in scenic Wilmington, Delaware. Well, so when DuPont found out what was going on, he and his business partner went to the Buck, determined to stop the recruitment. They beat Munns severely. I think that's something of a euphemism, and ordered him to leave the neighborhood, which he did. Munns, taking 2 DuPont powdermen with him, went to Richmond. They also took with them a brass pounder, some sieves, and some drawings of the machinery used in the DuPont powder mills. DuPont arranged for them to be arrested in Virginia and returned to Delaware for trial on charges of stealing the brass pounder and the sieves. But DuPont was concerned more than just with the loss of the things. He was concerned with the loss of the information. And so he inquired of a Richmond lawyer whether the company could do anything civilly to assert their rights to the knowledge, and was disappointed with the answer. According to the Richmond lawyer, DuPont could maintain an action for enticement, that's recruiting away workers, against the firm in Richmond, but because DuPont had not patented the design of the mills or the machinery or the pounder or the sieves, the lawyer said, "I rather think no action can be sustained for taking the copies, it being what the law calls damnum absque injuria," a Latin phrase you didn't learn from me in civil procedure, but you might have learned it in torts, basically a harm with no remedy. So learning that the law offered no protection for the information turned out to be an important lesson for DuPont. For some years thereafter, the firm chose to rely heavily on informal measures to protect what they regarded as their technological superiority. Plant security was a huge deal. Social sanctions, public opinion, these were the tools that the company used rather than legal remedies to protect the secrecy of its technology. Now here's an interesting thing. When DuPont and his business partner had a falling out, and they had an extremely acrimonious falling out not long after the Charles Munns episode, DuPont made no effort to prevent the business partner from using DuPont technology. The partner, Peter Bodie, started a competing mill on his estate near Wilmington. It was a very acrimonious departure. There was quite a lot of litigation about it. Yet the notion that DuPont had of the harm to him was quite different. DuPont's father wrote a letter to a French investor describing their view. He said, "Even though he has taken many of our workmen, though he uses almost the same machinery and methods of mixing, no powder compares with ours, all because of Irene's skill and his marvelous industry," meaning his hard work. And so there's obviously some class issues going on here, and when DuPont regards it as being wrongful to take knowledge. Today, the law of trade secrets would prevent both the powderman and the business partner from using DuPont technology. But in 1800, the only rights DuPont had were to the work of the workers, to the physical objects that they took, but not to the information contained within them. And so to the extent that they were free to quit, they were free to take their knowledge with them. A similar story could be told about early disputes between employers and employees over patents. And I'll skip that over at the moment. The same is also true of copyright, and I want to illustrate how this operated in copyright with a couple of anecdotes. Although in the last decade of the 18th century, slightly fewer than half of copyright registrations, registration was required for copyrights to obtain a valid copyright at that time, slightly less than half were by someone other than the author of the book. The law offered no way other than a voluntary agreement for an employer to claim the copyright of works created by employees. In a number of circumstances, employees or independent contractors did copyright works that they created at work, including works that they created in collaboration with other employees. So, for example, an assistant postmaster general, Abraham Bradley, Bradley in 1795 obtained one of the earliest copyrights for a United States map. The map was based on information provided by postal employees around the United States. And it was almost certainly drafted in connection with his official duties for the post office. Yet he copyrighted it in his own name and published it privately. The map became the official map of the United States Post Office in 1825, and the nature of his understanding with the post office regarding ownership or use of the map is not known. This wasn't an isolated incident. Soldiers who worked on surveying for General Washington in the Revolutionary War and for generals in the war with Texas, I don't know how to characterize that war, what's the politically correct way of the War of Texas Independence, I don't know, whatever. Soldiers who were involved in surveying during that war also copyrighted and privately published maps that they compiled in connection with their government duties. In addition, evidence from the field of law publishing, which is one of the reasonably well-documented areas of early copyright business, suggests that employee ownership of copyrighted works was assumed to be necessary to finance the creation of valuable works. The very famous 1834 Supreme Court copyright decision, Wheaton versus Peters, which was a dispute between the third and the fourth official reporters of the decisions of the United States Supreme Court. In that case, it was assumed that Wheaton, the third reporter, and Peters, his successor, the fourth reporter, owned the copyrights to their official reports of the decisions of the court, although not to the opinions of the justices themselves. But there was a whole lot in a report besides just verbatim transcription of what the justices said. And indeed, the only way that they could afford to prepare and disseminate the reports of the court would have been, or was, if they owned the copyrights and could sell them to the publishers themselves. So in this area, what we see is that business and law seems to have assumed that American economic development depended on giving every inventive person, including employees, almost complete ownership of the intellectual property they generated. Beginning in the 1860s and then picking up pace in the last few decades of the 19th century, courts began to back away from earlier decisions allocating contested intellectual property rights to employees. An 1861 equity case about the rights to certain parts of the very popular play Our American Cousin was one of the first cases to pioneer in this area. Our American Cousin is perhaps not familiar to you, but it was the play Abraham Lincoln was watching when he was assassinated. And it was a hugely successful play in its time. An 1868 case about patent assignment agreements and an 1868 case recognizing the right of an employer to control economically valuable secrets established the beginnings of employer rights to copyrights, patents, and trade secrets, respectively. Similarly, and this is an area that's somewhat outside the realm of what's traditionally considered part of intellectual property, but I think it should be, in 1874, a litigated dispute between the famed singer Johanna Wagner and her erstwhile manager led the court to conclude that Miss Wagner's contract to perform exclusively under the management of her manager, this guy, Mr. Lumley, could be enforced by an injunction prohibiting her from using her talent for anyone else. The doctrine of Lumley versus Wagner became a vehicle by which employers of people with unique talent could assert a claim to the exclusive control of the human capital of the employees. And so, in a sense, the Lumley doctrine replaced the tort of the action of enticement as the way in which employers could control employee labor, but it focuses on talent rather than just on work as the uniquely valuable commodity. Notwithstanding these legal developments, for a variety of technical reasons, they were relatively limited incursions into what generally remained, even for the latter half of the 19th century, a relatively employee-friendly legal regime. A valid employer claim to intellectual property generated by an employee generally had to rest either on an express contract or, particularly late in the century, on the employer, and the employer had to be a person, so his personal involvement in the creation of the valuable article, whatever it was, a book or a patent. In the latter half of the 19th century, courts were not as hostile to the enforcement of explicit agreements assigning intellectual property rights as they had been in the antebellum period, but only at the end of the century did courts regularly conclude that the fact of the employment itself, rather than a separate express contract, was all that was necessary to entitle the employer to the intellectual property created by employees. These developments of the law in the antebellum period, postbellum period seem to have had only a relatively modest effect on company practice. Even into the last third of the 19th century, firms were neither very systematic nor very effective in controlling the dissemination of innovation through restrictions on the portability of human capital or employee intellectual property. And so I want to offer you two episodes from relatively large and sophisticated companies who paid a lot of attention to innovation. The first is the Mcnally Company, publishers of maps and atlases. The company was founded in 1856 and from very early on was fairly acutely aware of the value of copyrights. In 1876, the company began publishing a banker's directory, which they claimed was they had employed this guy Charles Williams to compile. Williams claimed that he had developed the directory himself and had merely contracted with Mcnally to print it and then had gone to work for Mcnally to sort of supervise the printing. When their agreement regarding the sharing of the profits from this incredibly lucrative publishing enterprise broke down, Mcnally instituted civil and criminal litigation against Williams, charging him essentially with embezzlement of money while running the directory publishing part of Mcnally's business. Williams claimed that he was authorized to cash the checks in question. And although the case was not directly about their intellectual property rights, it does reveal Mcnally's anxiety about controlling their right to what they considered a fairly economically valuable part of their business. Williams was acquitted on the criminal charges, largely based on the jury's belief that he was authorized to do what he did. And he set himself up in competition with Mcnally in New York. And so Mcnally was somewhat anxious about their ability to protect themselves. Interestingly, one of the things you learn when you read the Mcnally archives is that lots of leading map publishing companies were founded by former Mcnally employees. The Hammond Atlas companies, if you've ever seen that one, Hammond left Mcnally in 1900. A major publisher of road maps that I'd never heard of, but evidently they were big in road maps, the H.M. Goucher company. Goucher left the company very acrimoniously in 1926. Mcnally sued him, but he became one of their major competitors anyway. Another example from the late 19th century involves the Reading Railroad, which I discovered only when I went to college, that it was more than a square on the Monopoly board and that it's not pronounced reading. You can tell I grew up in the West. Railroads in the last third of the 19th century were the sort of paragon of the large-scale bureaucratic corporation, and were also sort of a high-tech industry of the day. And so you would expect them to be fairly organized about dealing with employee innovation and control over it, and they weren't. I've read the archives of both the Reading Railroad and the Pennsylvania Railroad, which are very large organizations, and they both appear to have paid very little attention to employee ownership of patents. In the 1870s, John Wooten, who was the engineer of machinery and the superintendent of the Reading Railroad, very high-level employee, designed and built a new and more efficient type of firebox for a coal-fired locomotive. Essentially, Wooten's invention allowed them to use coal dust, which was regarded as waste, to power their locomotives, and since what the Reading did was bring coal out of the coal fields in western Pennsylvania down to eastern Pennsylvania, the ability to use this otherwise worthless coal dust was a huge innovation. He patented the firebox in his own name and informally agreed that the Reading could use it. But there was never a formal agreement. Wooten sold his firebox to many locomotive builders and railroads, and he personally spent a certain amount of his time supervising the initial runs of new locomotives using his technology, whether they were Reading railroad locomotives or locomotives being used by competing railroads. In 1889, 3 years after Wooten retired, the railroad's management became concerned about the road's right to use Wooten's patented firebox. The Reading's general counsel drafted a license for Wooten to sign that would have granted the road, quote, the use of all his machines, devices, and patents. Wooten wrote back in reply that he was perfectly willing to agree, except that he'd already assigned the patent to the firebox to the Baldwin Locomotive Company, which was a major manufacturer of locomotives. A few months later, one of the Reading Railroad's Allied lines wanted to build a few locomotives using Wooten's firebox and was informed that they would have to pay a substantial fee to license the patent. So then a very high-level employee of the Reading wrote to Wooten and asked him to see if he could reduce the fee, which Wooten said, well, yes, I will try to do. But what the correspondence reveals is that the Reading had no right to use the firebox, even though Wooten had developed it on the job using Reading employees, testing it on Reading locomotives. And in fact, the patent for it had been promoted, and the innovation had been promoted by the Reading to a fairly substantial degree. So they were essentially reduced to asking it to use it as a favor rather than as a matter of legal right. So come with me up to 1900. The years bracketing the turn of the 20th century were a transformative period for intellectual property and for the law of the workplace more generally. The era saw a massive transfer of idea ownership from employees to firms and a shift in legal doctrine that was catalyzed by and reflected profound changes in the work relationships in which novelty was generated. In a number of ways, Rand Mcnally's operations for the production of maps, globes, and atlases resembled the evolution of corporate research laboratories in other industries. Kodak developed one at this time, DuPont developed one at this time, Bell Telephone developed one at this time. And so I'm going to use Rand Mcnally as an example, but it's illustrative, not unique. Foremost among the similarities among all of them was the organized effort to develop new material and to improve upon existing company products. To do this, Rand Mcnally sought out associations with cartographers, draftspersons, artists, geographers, and then had them devote quite a lot of time to gathering information and improving the way that it was presented. When Rand Mcnally uniformly wound up with the copyrights to all the products that they developed, but they often credited employees as authors, both in communications internal to the firm as well as in marketing products outside the firm. And it's this notion of credit that I'm going to come back to at the end. Although Rand Mcnally systematically claimed patents and copyrights to developments developed by their employees, the firm's willingness to credit employees, I think, is somewhat unique as compared to other firms. One prominent example of this is Rand Mcnally's longtime affiliation with a University of Chicago professor of geography named J. Paul Good. Good first began working with Rand Mcnally in 1900 while he was finishing his PhD, 3 years before he joined the faculty of the University of Chicago. Rand Mcnally became the publisher of a huge amount of his work, including publications that were known as Good's School Atlas, Good's Wall Maps, and eventually Good's Political Globe. While Good, like other Rand Mcnally authors, assigned his copyrights in these works to Rand Mcnally, the company relentlessly promoted the products as being his rather than theirs. That they may have done so for the aura of scholarly authoritativeness that it would give by their affiliation with this Chicago professor does not diminish the fact that the company used credit and individual attribution as part of its business strategy. The original contracts between Good and the company are lost, but the extracts of them that I've found in the company files note only that he agreed to assign the copyright and their agreement regarding profit sharing, nothing about whether crediting him was a term of the agreement that they explicitly negotiated. Nevertheless, the precise allocation of rights, both intellectual property rights and credit rights, remains a little bit unclear. Rand McNally owned the copyrights, that's quite clear, and yet the University of Chicago evidently also owned one of the copyrights to one of his most pioneering developments, the Homolocene equal area projection. I don't know much about mapping, but what it is was a method of portraying a map of the globe on a flat piece of paper with minimal distortion. The 1932 edition of his school atlas lists Rand McNally as the copyright owner of the book. There is also a Rand McNally copyright claim for every single map in the book, stamped right on the map. And yet in the preface, Good thanks the University of Chicago, owners of the copyright, for permission to use Good's Homolocene equal area projection for the world maps in this edition. So what you see is a sort of an overlapping network of copyright claims. Now, Good was not unique in his relationship with Rand McNally in being somebody where credit for innovation was given. There was an employee named John Brink who was widely credited in the company literature, even outside the firm, with being, quote unquote, the father of roadmaps and the person who first conceived of the company's ambitious efforts to dominate the roadmap business, which was big business when people started driving around in their cars all over the place. He had his own art studio and was initially sort of an independent contractor with Rand McNally to draw maps. The company then, when their roadmap business was declining, were looking for a new way of marketing roadmaps and announced a competition to its employees for ideas for new products. And the employee who submitted the winning idea would win a $100 prize. Brink won with the suggestion that the company produce maps on which each road was identified by a distinguishing symbol and number to make them easier to read. Back then, roads weren't numbered, they weren't consistently named, and if you think about it, it makes it very hard to draw a map. And so the company adopted his idea, and his Illinois map, known as an Auto Trails map, which was published by Rand McNally in 1917, became the first road map to show numbers, and then Rand McNally wound up in copyright litigation to prevent unauthorized use of his road maps. And they then launched this huge business, not merely to make road maps, but then to go around posting road signs with numbers on them on roads all over the country so that they could number their maps and the numbers would appear on the roads. And Brink sort of oversaw this whole process. Notwithstanding the fact that he was a full-time employee of Rand McNally, he evidently remained an independent contractor for a large part of his career at the firm. The roadmap project did not formally become part of Rand McNally's company until 1926, when it had been in business for about 9 years in this road mapping area. And interestingly, a young cartographer who applied to Rand McNally for a job in 1923 was told to go see John Brink, who had a drafting room with about 20 employees on the 10th floor. Brink said to him, well, I make road maps for Rand McNally on a contract basis. I have a full crew, so I can't hire you, but why don't you actually go down and apply to Rand McNally and see if they'll hire you, which the company did. And so interestingly, they had this sort of complicated relationship with their employees / independent contractors in which they own the intellectual property but don't necessarily control it as thoroughly as you might imagine. So let me turn now from description to explanation. What accounts for the pattern of legal and business change that I have outlined? A lot of things do, but for the sake of brevity and clarity, I'm going to focus just on two. First, on some ideological factors external to the law, and then some conceptual changes within the law. First, external to the law, I think that what explains a lot of this in the 19th century is the overwhelming importance of the ideology of free labor in the 19th century, and particularly in the postbellum period, the tension between free labor ideology, and rising corporate power. The historiography of work in the 19th century has shown the pervasiveness of various ideologies about free labor, both before the Civil War, obviously, but also afterwards. Free labor was distinguished both from slave labor in the South and from what Southerners in particular were keen to call wage slavery in the industrializing North. And the freedom and independence of labor was widely considered to be both a defining characteristic and an essential precondition of American democracy. Courts adjudicating conflicting claims to the control of workplace knowledge saw over and over the connection to freedom of labor. And the reluctance of courts in the 19th century significantly to limit employee use of workplace knowledge was attributable to the widespread judicial perception that the employees in litigation were stalwarts of the middle class, whose independence was an essential bulwark against the tyranny that characterized both black slavery and northern wage slavery in the emerging factory system. Over the course of the 19th century, the notion of middle class changed, of course, and with it changed the court's view that employee control over knowledge and intellectual property was an essential feature of middle class status. In a sense, what you trade in is the sort of independent entrepreneurial middle class for the bureaucratic corporate employee, with stable employment, the man in the gray flannel suit of the 1950s era literature on what middle class meant, and the notion of a sort of a stable corporate career as providing the independence and social stability that was necessary to American democracy. So I think that the transformation story I tell at the sort of sociological level is about how evolving conceptions of freedom and independence and the rise of the large corporation influenced both courts and firms in how they handled creative people. Second, there is the evolving legal ideology of the nature of work and the role of changing notions of contract law and property law in regulating it. The surge of contract as the dominant conceptual framework in the rapidly developing field of master-servant law, what is today employment law, played a crucial role in courts reinterpreting and eventually reallocating ownership of ideas. The cases reveal a tension between two different discourses. There's one about contract and work relationships and a second about property relationships. In the contract discourse, the employment relationship is only a contract. The role of the law is simply to identify and enforce the agreement of the parties. And the transformation here is in how the courts understood the contract between the creative employee and his or her employer with regard to ownership and control of both the process and the products of creativity. Particularly the development of implied contract in the late 19th century, what was then called quasi-contract, enabled the development of a new way of thinking about what the terms of employment are, replaced the earlier sort of status-based notion of employment obligations in which independence was crucial with a notion that all employment was contractual, that terms could be implied, and that everything was essentially transferable. The evolution of property discourse, I think, proceeded on a similar path. Early in the century, the employment relationship was a status relationship in which the rights and obligations of employer and employee adhered in their status. And ownership and control of knowledge and creativity was framed, but in limited ways, in property terms. As legal conceptions of the nature of property changed over the 19th century, the ability to imagine knowledge as property changed. In particular, property notions changed from a notion of absolute dominion over things, that characterized early 19th century property thinking to a notion of property ownership as a fragmented relationship among people concerning things, but also concerning intangibles. And thus it became easier to understand knowledge as a thing and knowledge as something that could be owned, shared, divvied up, or transferred in a way that previously had been sort of conceptually hard to grasp. I think that both of these were, both the sort of evolution of contract, the evolution of property, were facilitated in really important ways by the emerging phenomenon of the legal treatise. Not only did treatises sort of organize and systematize and in a way expand what courts could understand as part of the employment contract, they enabled a notion of a kind of a unified field of employment obligation that could include employee knowledge. And thus the development of treatises sort of expanded the notion of what's in an employment contract and thus sort of facilitates the notion of an implied contractual duty to assign patents or to guard trade secrets. So let me now conclude by raising some normative questions about the significance of assimilating the history of workplace knowledge into the history of intellectual property. In defining the scope of my project to include workplace knowledge, broadly speaking, rather than just copyrights and patents, I am defining the ambit of intellectual property more broadly than anybody did in the 19th century. I'm not the first person to have characterized in property or property-like terms the value of worker knowledge. Frederick Winslow Taylor, who was an early 20th century guru of efficiency and sort of the father of management consulting, did too. He described, quote, the massive rule of thumb or traditional knowledge as the principal asset or possession of every tradesman, and Taylor's life's work essentially was to transfer that asset from the tradesman to the corporation. But I think that when I do this, the expansion of both the subject of intellectual property and of the methods that I've used to study it, not just cases but business practices and looking at it broadly defined, has normative significance. When I characterize as corporate intellectual property the right of an employer to prevent a former employee from competing through an action for enticement or through breach of an agreement, an exclusive agreement to perform, I change the way we understand work relationships, but I'm also contributing to the expansion of intellectual property in a sense. The historian's craft compels me to consider all employee knowledge as being like intellectual property, even as I recognize that it wasn't regarded as intellectual property at the time. As a lawyer, however, I am acutely aware of the role I play in expanding the category of intellectual property by exploring the full range in which firms control employee knowledge. To recognize employee knowledge as a valuable commodity, however, is not to decide who should control it, or even that it should be exclusively controlled as a form of property. The historical record reveals that as corporations increasingly gain control of patents, copyrights, and trade secrets, other social forms of acknowledging individual creativity emerge. And I speak here of credit, the credit that Rand McNally gave Paul Goode and John Brink, the credit that you might be familiar with that every Hollywood movie accords the hundreds of people who work on the movies, including, if you read them closely, the lawyers. That could be you one day. How credit for creativity or innovation is claimed or given, how it is economically valued in the labor market, and how it is socially and psychologically valued in communities is an important aspect of intellectual property, I think, and it is not yet thoroughly studied, although that's going to be my next project. Treating credit as a form of intellectual property might be desirable, it might not. The point is that as an expansive notion of the proper scope of study of intellectual property will not necessarily contribute to the expanding realm of corporate intellectual property. It simply opens up some stuff for us to think about. Now, I think that we need to think about, though, the normative significance of simply expanding the term intellectual property. The field of intellectual property, like the universe, is expanding in multiple directions and has been for a few centuries now. The outer boundaries of the IP universe have expanded as more and more forms of information like computer programs, photographs, recorded music come within the protection. And in addition, the constituent parts are expanding themselves. So copyright, for example, covers information for a longer period of time, more forms of expression, and not merely just new media, but different ways of expressing the same thing. And so let me give some thoughts about the challenge of trying to decide from the historical perspective what's in and what's out when I define what intellectual property is. To do this, I decided to look up what the Oxford English Dictionary thought was the first use of the phrase intellectual property. Not that they're necessarily authoritative about it, I just was curious. And they say the term first appeared in 1845 in an opinion of a federal court in a case called Duvall versus Brown. The case arose from a Fall River, Massachusetts textile business and involved an improvement in mechanized cotton spinning. And the judge who decided the case, Justice Woodbury, said that intellectual property was should be broadly defined. Only thus, he says, can ingenuity and perseverance be encouraged to exert themselves in this way usefully to the community, and only in this way can we protect intellectual property, the labors of the mind, productions and interests, as much a man's own, as much the fruit of his honest industry as the wheat he cultivates or the flocks he rears. And so he's using the sort of Lockean vision of the labor theory of value as a justification for broad intellectual property rights. In these terms, the notion that one could enjoy a property right in the product of another is not terribly controversial. It's no more controversial than buying somebody's wheat or their sheep, or indeed employing somebody to raise your wheat or raise your sheep. But there were other rather dodgier, in my opinion, associations to the idea of owning another's intellect or the products of it. When I began hunting up old cases using the term intellectual property, and particularly in the context of somebody else owning it, I found an 1836 decision of the Supreme Court of Tennessee in a will dispute about whether a widow who had a life estate in a plantation and in the slaves on it could take the slaves to her new home in Mississippi. And the issue was whether removing the slaves from what the court characterized as the humane and healthful conditions in Tennessee to the more oppressive legal and physical climate of Mississippi would impair the future interest of the person who was going to inherit the slaves on the death of the widow. And so the court remarked on the need for full protection of the, quote, peculiar nature and character of slave property. Slave property, the court said, encompassed, quote, a property in intellectual and moral and social qualities, in skill, in fidelity, and in gratitude, as well as in their capacity for labor. Now, slave cases are not typically regarded as intellectual property cases. They were property cases, or else they were slave cases. And I should say that in the Tennessee case, ownership of the slave's intellectual product was not an issue in the case. But if ownership of intellect, skill, and fidelity are, quote, the peculiar character of slave law, then the notion of intellect as property, the notion of loyalty as property, is problematic. And so what I mean to suggest here is that the label we attach to the concept of owning knowledge or owning the product of intellect as a consequence of the work relationship is not politically neutral, and it never has been. By drawing the connection to the slave cases, I have made a deliberate conceptual and rhetorical move, casting doubt on the morality of transferring through employment the legal rights to the works of another's mind. But I don't include the slave cases in my book. I do include the enticement cases. And so what is the justification for drawing the line? And should I include the slave cases? What any of us, when we're drawing the lines, what are we doing? And I think that's the open question for me. I'm thinking, gosh, do I need chapter 6 on the slave cases? Let me conclude by explaining why I think we need to take a broad view of the use and control of employee knowledge. And I'm going to bring this in with a 20th century example. What we see, or 21st, what we see in this area is the fairly consistent unwillingness, both by courts and indeed in businesses, entirely to obliterate the creative individual, the hardworking, innovative employee. And that persists even for rhetorical purposes today. Consider the recent campaign of motion picture studios to discourage the unauthorized duplication of DVDs. To make the case that piracy is bad, the Motion Picture Association of America ran a series of short spots that showed before the previews in movie theaters. Each featured a worker who contributed to the making of a film. The worker describes how he feels about his work on the movie, how important his talent and hard work is to the success of the film, and how piracy in effect steals the worker's property by robbing them of a chance to work. The spot featuring a set painter named David Goldstein is a great illustration. He was filmed on a set construction site talking about his work. Piracy is bad, he says, because it does not really hurt the producers, or he corrects himself, it does affect the producers, but it's minuscule to the way it affects me, the guy working on construction, the lighting guy, the sound guy. And then there follows a montage of the popular movies he's worked on with his voiceover saying that he met his wife making The Big Chill. And then as the Motown soundtrack to The Big Chill fades out, David looks very heartfelt and he says, I'm not a $1 million employee. I'm lucky if I can put together 12 months of work in a year. All I want to do is the best product I can. And then it closes. So the honest labor of a guy in work boots and a flannel shirt is the movie studio's best or most persuasive claim to own the copyright to the work he generates. Now, David Goldstein here is being used, therefore, to protect a fairly broad regime of employer copyright. His own reward is his salary, but I think maybe his reward is something else. It's screen credit. In Hollywood, screen credit is an extremely bankable commodity, even if we tend not to think of it in intellectual property terms. I've known people who've worked on movies for free just to get the screen credit, and the Writers Guild and other guild agreements have an elaborate regime for allocating who gets screen credit and who doesn't based on what. What the 130 years of history I have offered you today suggests, at least to me, is that the rise of corporate intellectual property may both generate and necessitate new forms of acknowledging and rewarding the contributions of employees. Understanding the social context of the creation of new ideas and the social context in which innovation is identified, how do we know it's new, labeled, yes, we're going to call this new, attributed, the newness is attributable to so-and-so, parceled up into legal rights, there's copyright, there's screen credit, what else might there be? And compensated, or not, is a necessary step in thinking about questions of equity and fairness in the process. And I think the history reveals that law and business practice have always interacted in an ideologically charged and historically contingent way in the process of both commodifying and rewarding innovation. And the question for the future is how that process can be administered equitably and with appropriate regard for whatever set of values we think we should hold dear. Thank you. I talked for 45 minutes, what I was told to do, but if there are any questions for those of you who don't have to race out, I'm happy to answer them. Or if you've got to take off, feel free. Jared?
Well, thank you for the very stimulating work. And I would also point out I was reviewing a book on the history of intellectual property, and they have devoted a lot of attention to your work, so it's having an impact. My questions had to do with the implications for 21st century in two areas. One question is, it said that the California Silicon Valley explosion, and a bit like the similar explosion in the Italian design industries, was aided by a refusal to enforce agreements restricting further employment, restrictive covenants on contracts about competing relationships of workers. And I'm wondering if you have studied that, if you have anything to say on that. The second question, I'll just put them together, is looking further ahead. Schumpeter had this idea that we were going to have these big research think tanks, and they were essential, so we should encourage monopoly as much as possible, because it's the only way we're going to get any innovation. And then, of course, two things happened. The government exploded Bell Labs and IBM, which Maury thinks was actually the making of our 20th century innovation. And the other thing that happened is that the basic research was shifted to the universities, which became the government-funded think tanks. And so but this has had, I think, and is having, in ways that I'm only, not only beginning to intuit, but not deeply understand, a lot of implications on the employer-employee relations of universities. Have you any pithy comments about this evolution based on your historical inquiry?
Yeah, I think that you're right about the significance of the Silicon Valley episode. I haven't studied it in detailed way and empirically myself, but it seems to me that all of the studies that I have seen of it, and lots of people have concluded that it was the mobility of employees among firms that generated the rapid pace of innovation that existed in Silicon Valley. And that what people are now thinking about is that innovation may occur best when it occurs in a network among firms, not necessarily within the four corners of a firm. There is some historical precedent for thinking of this. So one way of understanding the railroads, for example, and their reluctance to assert intellectual property rights in as systematic a way as they might have, is that they actually thought that a network of communication among the highly skilled people, so that John Wooten at the Reading was constantly talking to somebody, his counterpart at the Pennsylvania, who was talking to somebody at the other railroads. The network of communication among the railroads and the locomotive manufacturers is what drove innovation, and it's when they stopped doing that innovation slowed down. And I think there's been a lot of literature on this. Artie would be a better source on this than I am, but innovation among pharmaceutical firms, the thought that the big companies tend not to be driving development as much as smaller firms, and big companies essentially acquire patents. They don't develop them themselves. And I think if we're persuaded that this kind of network effect and the transmission of knowledge among organizations is crucial for innovation, then I think that the scope of intellectual property rights, particularly vis-a-vis employees, needs to be rethought. And I think a lot of people think that's de facto that's happening already, that everybody's cross-licensing, they're coming up with arrangements. And the question is, in economics terms, is how to design a legal regime that minimizes the opportunities for being opportunistic, because it's ultimately going to be in the best interest of all to have sort of mobility of employees and therefore ideas. Jamie?
Wonderful presentation. Two quick questions. Free labor ideology wouldn't presumably have prevented the companies from contracting up front more than they did. So I think, I don't know, I mean, looking at your prior work, most of these are sort of, well, there was no agreement, there were gaps and so forth. And after all, the courts were enforcing yellow dog contracts and other kinds of very restrictive contracts. So were the companies, as you were saying, like the railroads, is that what they were doing, or were they just stupid in ways that economic theory would not predict what was going on? and then the second one is, our dear friends, the economists, would tell us that it is impossible to redistribute income by changing private law rules because people would just contract around them, and so they would assume that if people change from a default rule where you don't own where you own your own intellectual property to the default rule that the company owns it, then you would expect a transfer, a monetary transfer, that people were basically getting compensated in other ways, through job stability or through higher benefits. And that I think will be the thing that the economists will immediately say in your book. It's like, well, you need this other story. You need the story about wages, conditions, benefits, tenure. Do you have any of that?
Do I have the data that the economists would want?
No.
No. But if somebody wants to write that book, bless them, I will be so excited to read it. Hard information to gather, unfortunately. I mean, working in 19th century corporate archives is really a challenge because lots of the stuff isn't there anymore. I think that the question of why didn't companies contract around it? They tried. Many of them did. It was very hard to get a court to enforce those contracts, particularly in the patent area. Courts tended to construe patent assignment agreements incredibly narrowly against the employer, finding almost any reason you can think of why it didn't cover this patent or the agreement wasn't enforceable, or sometimes, for this reason, or sometimes simply saying, the agreement is just void because this is just an outrage. You cannot, they had all sorts of lofty language for it. This is a mortgage on the man's brain, et cetera. Sort of the inalienability of knowledge. But to the extent that they didn't, I think that there are a couple of reasons. One is the assumption that everybody's going to contract around it is an assumption that everybody is thinking about this when they go into it, which they may not be, particularly with general purpose employees who aren't, being hired to invent, that the firm has competent lawyers. In the 19th century, many firms didn't have regular legal advice. And so DuPont's practices, which I didn't talk about today, but changed a fair amount when they got this very aggressive patent lawyer who was going to make his career out of being sort of the employment IP guy. So they didn't necessarily get the legal advice, and of course on the employee side, they're not getting legal advice. And then finally the question of were there reasons why, even if their lawyers said that they should do it, they might not have done it? Going into an employment relationship is a very dicey situation, and it's why people tend not to contract around the at-will rule. When I'm negotiating for a job, the very last thing I'm going to do is say, how much do I have to screw up before you can fire me? Can you fire me just because you don't like me, or do I have to really screw up, and if so, how? Because it tends to signal slacking. And so talking about an issue that's going to be difficult, like are we going to innovate, how, who's going to do it, how are we going to divide it up, when it all seems somewhat speculative, even if your lawyers tell you you should, when you're talking about getting managers and employees actually to do it, there are some obstacles to that. So I think at least in the 19th century, the notion of the ability easily to contract around default rules in the way that now you would expect firms to do, I think is a little bit unrealistic. Barak?
To kind of add to this discussion, I wonder if of the variables that you mentioned, one of them is simply the institutional capacities of the courts in the early 19th century. I'm struck that there was nothing culturally inappropriate with exercising extreme control over slaves in the black and low-wage earners in the North. But suddenly there's a very marked change in the discourse over controlling someone in the middle class. I wonder if the discourse really is just a reflection of what was legally feasible. The first story you had, where the answer was you have a harm with no claim, I wonder if it would have been more accurate to say you have a claim, but the courts can't do anything about it. In which case, maybe everything would really be adjusting to the limitations of the courts at that time.
Right. Yeah, it's an interesting question. I mean, I do think that, and in a way, the limited institutional capacity of courts to adjudicate these claims is sort of related to the limited availability of lawyers to advise on IP issues. And particularly some of the very early cases where you have the justices deciding them, riding circuit, you do have, I think, this sort of awareness. I mean, you don't see it explicitly in the opinions, but the awareness of the difficulty of figuring out retrospectively what went on and coming up with a remedy that would be a meaningful remedy. And you certainly see that in the area of protecting trade secrets. The question of how to enforce trade secrecy is a huge one and has been since courts first went down that path. Steffi?
did you consider since you looked at this specific historical time, were you able to find out what the influence of early internationalization of these companies were? I mean, DuPont then went back to Belgium, actually, and did comparable work there with quite a different legal regime, at least in the early 19th century. So I would be, find it interesting to see what influence that had.
It would be fascinating. As a matter of historical records, it's extremely difficult to do that kind of work. Because, for example, when DuPont went back to Belgium, and their operations in Europe were very distinct from DuPont in the US because of the difficulty of communication, et cetera. There's also, at the same time, the question of the interest of US firms in being able freely to pirate foreign technology. There's a hilarious episode involving DuPont, in fact, in about 1917 or 18. Germany and German scientists had a virtual monopoly on the dye business. German chemistry, dye chemistry, was far superior to anybody else in the world. And so German firms were doing a fairly brisk business in the US in dyes, and with the outbreak of the First World War, sort of all bets were off. And suddenly what happened is DuPont was trying to recruit German dye chemists to bring what were regarded as either German patented or trade secret dye technology to DuPont, and they got caught. And it wound up being a fairly embarrassing public relations debacle when they were recruiting these German dye chemists, and the guys were intercepted at the ports with suitcases full of chemical formulae for different dyes. And the American branch of, I think it was Bayer, was the German firm at the time, was just outraged that DuPont had done this. You care so much about IP rights, which DuPont said, well, gosh, it doesn't make any sense for us to reinvent the wheel. These people have all the information, which was just hilarious given the position that they had taken. And certainly Rand McNally had the same thing about intellectual copyright. So I think that their international operations presented both a logistical challenge in terms of a different legal regime, but also a PR challenge given the absence of international intellectual property protections at the time. That doesn't go to the sort of second part of your question, which is to the extent that I'm making causal claims about the rise of industrialization and the effect that it had on intellectual property law, how do you explain the somewhat different legal regimes in Germany, for example, and in France, particularly in copyright, where they both have a concept of moral rights that doesn't exist in the US law. And early on, when people have made this comment to me, I thought, maybe I ought to do that. I decided, all right, that's my next book. After I learned to read German and French.